All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. Please be seated. Welcome to the First District Court of Appeal. We have two cases on the docket this morning. The first one is Palafox LLC versus Carmen Diaz. And Mr. Parker Flynn, are you ready to go? You may proceed.
Thank you, Your Honor, and may it please the court. My name is James Parker Flynn. I'm here on behalf of the appellant Palafox LLC, and I would like to reserve 4 minutes of my time.
Would you pull the mic just a little closer to you?
I absolutely can.
Thank you.
This case involves...
How many minutes are you reserving?
4 minutes, Your Honor.
4. Okay, I got it.
Thank you. This case involves one simple issue: whether, once an administrative law judge has made a finding that an attorney has violated Section 120-569-2E by filing a pleading for an improper purpose, whether that administrative law judge can nevertheless determine not to impose any sanction at all. As is made clear by the plain and unambiguous text of that statute, the simple answer to that question is no. Once a violation has been found, the presiding officer shall impose a sanction. In failing to do so here, the administrative law judge not only erred as a matter of law, she also created an incongruous situation where the appellee's counsel was not sanctioned for his improper purpose in filing the pleading, but in a separate order, his client was sanctioned for her improper purpose in the proceeding, which, as was conceded in the answer brief...
So if this was the first time we were looking at this issue, I think you'd be correct, but she cited Mercedes, and Mercedes seems to say that there is a requirement to file your motion in a more timely manner, or you may not get your fees.
Your Honor, we feel that the administrative law judge erred in relying on Mercedes for a couple of reasons. The first is that any language regarding the timing of the motion for fees in Mercedes is actually dicta in that case. This court in that case found that the appellant had not filed his bid protest for an improper purpose. Without an improper purpose, there can be no sanction under the statute in the first instance. So any additional language about the timing of a motion is exactly the kind of additional language that's immaterial to the ultimate outcome of the case, the kind of language that this court has warned, has no binding legal precedent. But
well, I think would you agree though that the motion, at some point there's got to be an end to it? So I mean, the motion couldn't be filed 6 months after the final order.
I don't know that the motion could be filed 6 months after the final order. I do think that if we look at Mercedes and the federal sources that it cited, what we see is that it does not say that the motion must be filed close in time to the offending paper. What it says is it must be filed when there is a basis to do so, when that has become discovered. And the cases relied upon by the Mercedes court and also by the appellee in the brief make that very clear. So for instance, in the case of Henry Yagman, which was cited by the Mercedes court and the appellee, the court there note says when a paper is so obviously and recognizably frivolous, we want to see that motion close in time. And that's language paraphrased by the Mercedes court. But Yagman also makes clear that there are many instances when a claim may appear to be genuine on its face, where that claim may even survive summary judgment challenges and only become apparent, or as the Yagman court said, will only be unmasked as unfounded after the evidentiary portion of trial. In the court.
But I think the basis that improper purpose was found was Mr. Braswell had filed all these claims before, and they'd been fully litigated in different cases, and he should have known that bringing him forth again with just a new plaintiff was frivolous or improper.
Your Honor, that was part of the basis of the improper purpose finding. Additionally, the administrative law judge cited to Mr. Braswell's conduct in conducting discovery, or in fact conducting no discovery, and his failure to put on any evidence at the hearing that would have supported those claims. And I think this goes back to that issue from Henry Yagman. We're talking about the difference between obviously and recognizably frivolous papers from other kinds of papers. While Mr. Braswell had raised many of these claims before, his amended petition nevertheless raised a host of highly technical expert issues that, if proven true, and if supported by evidence, may have supported a finding that the ERP was not properly issued.
So if there is a timeliness issue, could that not be used to determine what type of sanction is appropriate as opposed to whether or not a sanction is required if there is a finding for improper purpose?
Yes, Your Honor, that is exactly where it comes into play. The statute, again, shall impose an appropriate sanction, doesn't give discretion to award none, but what these authorities make clear is that in considering any of these outstanding mitigating factors, it's part of the determination of what the appropriate sanction is. And I think it's also important to note that those...
So if we remanded to Judge Van Wyck and directed her to basically figure out what the appropriate amount of fees would have been had y'all filed a motion to dismiss right after the complaint was filed, would that be satisfying to you?
If it was only based on the failure to file a motion to dismiss, no, that would not be for a host of reasons. Because again, as these sources make clear, you don't just look at that. What you really look at is what Judge Swarzer in the article cited by Mercedes says. Did the moving party have any disproportionate expenses? Did the moving party itself do anything to create unnecessarily lengthy and complex proceedings? And I think the record is abundantly clear here that Palafox did not do that. So first of all, Rule 11, which is all these sources that are relied upon in interpreting 12569 sub 2E, frequently these cases are dealing with protracted civil litigation that lasts years. In this case, it was administrative litigation, which, as this court well knows, moves pretty fast. So between the time of the filing of the amended petition on the last day of October in 2019 through the final hearing in February 2020, 3.5 months had elapsed. That was it. During that time, Palafox retained an expert to evaluate all the claims made in the petition. It relied on the limited written discovery propounded by the Water Management District. It did not issue or serve any additional or duplicative discovery that was unnecessary. It deposed Ms. Diaz herself and their stormwater expert, but not every expert on the expert witness list provided by the appellee, and it presented 2 witnesses at trial. Neither did it engage in any outstanding motion practice to make those proceedings more complex or lengthy. In fact, it filed 3 motions during that 3.5 months. Its unopposed motion to intervene, a motion for official recognition, and a motion designed to keep the proceeding from becoming more lengthy, a protective order where Mr. Braswell sought to call a project engineer as an expert witness, didn't want to pay him an expert witness fee, and also asked him to produce at hearing boxes of files that had not been requested in discovery.
Well, given that you knew all of that before the final hearing, why wasn't the fee motion filed before the final hearing, and why wasn't it mentioned in the pre-hearing, I guess what in trial court you call the pre-trial the pre-hearing stipulation here?
Your Honor, again, as we were going through this process, and again, it's 3.5 months, we have to evaluate a number of highly technical claims made within the amended pleadings. You have to go through all the discovery process first. Once we got to the discovery process, a month before the final hearing, Ms. Diaz was deposed. In her deposition, she says, I don't even know what I'm going to testify to. Mr. Braswell says, we haven't even gotten far enough in our case to know what the testimony is going to be. So it was also important to see, is there any testimony that's going to come out in this hearing that could support that claim? Likewise, Mr. Braswell seemingly intended to rely on the Water Management District's experts through examination to prove his case. He didn't have necessarily fact experts on this. We needed to see, before we file a sanctions motion, whether there's actually any basis for these claims whatsoever.
So is it your contention then that when the ALJ said you needed to identify a concise statement of issues of fact which remain to be litigated, you were somehow able to not file the motion at that time?
Your Honor, I don't think that there's a requirement for a motion for sanctions be filed at that time. I don't think that that was necessarily an issue of fact at that time. Again, it required the full picture, which is reflected in the ALJ's order that she needed to see that full picture before making an improper purpose determination. She needed to see what happened before the pleading was filed. She needed to see what happened during discovery. She needed to see what happened at hearing before she could even make that finding.
As mentioned in Mercedes, and I know you contend it's dicta, but that the purpose of the statute is to avoid this protracted, unnecessary litigation. And certainly, it's been a long time since I've been in federal court, but 57105 has the 21-day time limit that's absent in the 120s. But how does waiting until after the hearing is complete accomplish the purpose then of the statute in the 120s?
Well, I think the court in Yagman, again, makes it clear that even when you have to go through that evidentiary portion of trial before the basis becomes clear, the deterrent purpose of the rule is still served by deterring any future inadequate pleading, not only by the certifying attorney, but by the trial bar in general. And that's exactly what the Yagman court said. That's the purpose of it. I think it's also important to note that in the materials, the Schwarz article, again, relied on by the Mercedes court, these were always things to be considered in the what sanction was available. And Schwarzer reminds that it's not just for deterrent purposes, it's for penal purposes as well. So all of those purposes can be served to ensure that this doesn't happen again. It also should be noted that this, while filed after the final hearing, was still filed before the recommended order came out, was still filed before the final order came out. There was potentially still time, if Mr. Braswell and his client desired to withdraw a claim, they could have done that. They did not do that. So again, what we see from all of these sources, first, the plain text of the statute says you got to impose an appropriate sanction. All of the sources say when you're looking at that, we're looking, did you reasonably respond to these claims? Did you do anything unnecessary to make them worse or disproportionate charges? This court will soon see in a related appeal filed by Mr. Braswell on behalf of his client against the attorney fee award against her, those fees were entirely reasonable.
So this order found an improper purpose on behalf of Ms. Diaz and Mr. Braswell?
No, this order was only directed towards Mr. Braswell.
Okay.
There's an additional supplemental recommended order at page 1095 of the record, in which it found that Ms. Diaz under 12595 had participated in the proceedings for an improper purpose, a slightly different standard. There's a prevailing party standard there as well. That had to go up on a supplemental recommended order, and then everything beyond that is not in this record. It is in the record of the related appeal for which Mr. Braswell filed his brief on Monday. There's relevant information in there. It's outside the record. I'm happy to discuss it if this court likes, as it's in its files. But the simple fact is the statute requires the imposition of a sanction. The statute makes no mention of the timeliness of a motion.
And you can keep going, but you're into your rebuttal time.
And the administrative law judge erred in failing to impose a sanction as opposed to considering all of the evidence about what the appropriate sanction should be in light of all of the evidence. So for that reason, we would ask that this court reverse and remand with instructions to the ALJ to determine what the appropriate sanction should be. One final note, the appellee spent basically the entirety of the brief arguing that the finding of improper purpose was error in the first instance. The appellee did not cross-appeal on that issue, and this court's precedent makes clear you have to cross-appeal adverse portions of an order. You can't simply raise it for the first time in an answer brief. So those issues are waived for appeal. They are not before this court today, and I will reserve the remainder of my time.
Good morning, Your Honors. I am Jefferson Braswell. I represent the appellee, Carmen Diaz. I guess, should start by saying how seriously I take the issue of sanctions against me. I have worked this case as hard as I know how.
We all understand that.
And I think that the record and the quality of the work, I hope, speaks for itself.
Well, doesn't that go, though, to the improper purpose? And as was pointed out, you didn't cross-appeal that. So that finding you're stuck with, right?
No, Your Honor, I don't agree. I think any time when there are sanctions, if we look at the Mercedes case and the precedents under Rule 11, if I'm being sanctioned, I think this court absolutely has the authority to go review the record and determine that there has been some type of misconduct or something that would warrant the sanctions.
We certainly do if somebody appeals that, but you didn't appeal that.
Well, I think that in a sanctions case like this, that the precedents suggest that this court has the authority to properly evaluate the evidence in total. And so
I'm having a hard time with that because generally our role is to determine whether issues that are brought before us that are alleged as error on behalf of the lower tribunal we're supposed to determine whether there was error, but it has to be brought to us. So my understanding is you needed to do a cross appeal, or you're stuck with that finding, and the only thing we're here to argue is whether a sanction should have been imposed or not, and what if any effect of the lack of timeliness of the motion has on the amount of that sanction.
What I can say is first of all, I don't want to spend all my time arguing this point. Sure. Because I think that there are significant issues related to the timeliness, the strategy of why we're even here, so forth. I do not look at this motion as really being filed in good faith. I think if they wanted to do that, if they wanted to file the motion for sanctions, they knew about this at the time the petition was filed. There was no secret as to what this case is about. This is about the ability of this property owner to fill in 2 acres of stormwater basin, 92,000 cubic feet, and dump it into a conservation easement that it doesn't own. So as far as, why we have filed it, we are here in good faith.
So what about their argument that, there were lots of technical allegations in the complaint that, had you been able to bring forth evidence to support them, would have made it a valid complaint and not for an improper purpose? But the fact that you didn't bring forth any evidence or any new evidence that you hadn't brought in any of these other proceedings, that made it improper.
Well, see, I think we're getting right back into the de novo review of the entire process. Look, we presented the evidence that we needed to show they don't have the right. They had to move their case off of the application materials. So there's no place in the application materials where they say this is a water of the state. They completely made that up in the administrative hearing. We forced them to go that direction. And so now they're saying, well, we get to use Ms. Diaz's land because it's part of a water of the state, and that's just simply not the law. The rules of the Water Management District clearly require that proper authorization and ownership is there.
You're arguing the underlying case, and I think we're just here on I know for sure we're just here on the issue of fees.
Well, I just want this court to understand that issue is valid.
Your argument that I should have won on the merits of this is not something that we really can take up.
It applies to the position of sanctions, though. If this court does a de novo review and looks at the record and determines that our case is valid, that they really do not have the authorization, that their wetland delineation really was 17 years old, that the statute doesn't permit it to go forward. If you look at those, then this court should be satisfied that our case is valid, that we are correct.
Can I ask you a question about timeliness? How do you respond to Palafox's argument that Judge Ray mentioned that the delay in filing the sanctions motion perhaps goes to the amount of fees that should be awarded, but given that there's no time limits in the statute, there's no specific timing on when the fee motion must be filed?
Yes, Your Honor. The Mercedes case, which is well-established 1991 precedent in the First District Court of Appeals, makes it clear that there's a procedure and a process that people have to go through in order to make their claim for fees. One of the things that we cited to was the Wilson recommended order out of DOA, where Judge Alexander goes through a long list of cases that are at DOA where they come in just prior to the hearing, or they come in at the hearing. And in each one of these, this is at page 40 of that decision, there's at least 5 or 6 examples.
And these are DOA cases?
These are DOA cases. Okay. So these are, well, there's no real precedent other than Mercedes in this court. So I think we've got to go and look at what DOA has done over the years.
And that's persuasive. I mean,
and hopefully it is. I understand that it's limited, but it should be persuasive. And in each of those cases where the petitioner for the fees comes in and does it at the opening of or after the proposed recommended order. Each one of those is rejected as not being timely. And it's because of this nexus with Rule 11, the federal rule, where the precedent is long-standing that if you want fees, you got to plead them. And now, you know, I make the argument, I'm much more of a civil practitioner these days, but even in Stockman Downs, even in the Supreme Court.
That's clear under Rule 11, right?
Right.
It's clear, okay.
So you're going to make this claim, you don't wait until, and lay in wait and sucker punch your opponent. And that's exactly what I'm dealing with here, is that they waited until their proposed recommended order. Now, keep in mind that our response was, we withdrew the petition, settled with the Water Management District. We had what we wanted, which was the record. We have their decision. We know they're using our land inappropriately. We know that they don't have the right. We got what we wanted. We settled. And if we offered, you know, we wanted to settle with them too. But they wanted to go forward with this claim that they dropped on us at the proposed after we had already filed ours. So there was no way for us to respond. There was nothing that we could do. And this is part of the strategy, is to trap us into this and separate me and sanction me and separate me from my client.
Well, and the ALJ seemed to agree with you in ruling that you know, the motion wasn't timely filed. But she had an order that's somewhat confusing to me. Order on issues for post-hearing submissions, which is 214 in the record, where she said, to clarify for the parties the issue of timeliness of petitioner's renewed petition for attorney's fees and sanctions is not cognizable in this proceeding and should not be addressed in the proposed final orders. But then she addressed timeliness. What does that mean? Does that have any impact on what we're doing here?
Yes, the ALJ has a lot of confusion, and I think you'll see it perhaps more in our appeal that was just filed on Monday. But I'm not sure I really understood where she was going, but I did understand it sufficiently to say you can't argue that point in our, I don't want to hear it. And so I think we were left with no other alternative but to comply with what she said. I'm not sure.
But then you won on timeliness anyway, so did that language that she had there matter? Is there anything?
Well, yeah, I think it should show this court kind of the sporadic nature of this whole process at the end. I mean, on the first day of the hearing, we got into counsel for the appellant trying to introduce the other recommended orders and other things into evidence, and the ALJ said, no, we're not subject to stare-decisis here. We're not subject to those opinions, and so I can take them and consider them, but I'm not bound by the Leon County ruling. We've got to go through our own process, and that's really what I would say here is that, the fact that there are two proceedings, the Leon County Planning and Zoning, which is all subject to the Snyder case, where this Florida Supreme Court goes into the county commission. I understand it was tried at DOA, but that's unique to Leon County. And then we have the 12057-1 proceeding, which is an administrative process going in front of the Water Management District, arguably not quasi-judicial, because there's not supposed to be any politicians over there. And so when we go forward on our presentation, a scientific presentation, we're supposed to have a better audience. They have their own rules. So counsel likes to argue, oh, well, you should have known that it was going to be the same result. But there's a whole body of rules, and especially those dealing with the authorization and so forth. So when we go forward on these matters, we go forward in good faith. In fact, I would suggest that I'm right. I mean, I think it's clear. Now, we didn't take this case up on appeal, and we have legitimate reasons for doing so. We believe Our best case lies with private contracts, developers' agreements, the conservation easement, because they're using a conservation easement now as a stormwater basin. So the deeds to the property, which provide no easement. So we think that our strategy is legitimate and sound, that we have acted appropriately when somebody's coming in and trying to take your property and dump all their stormwater on your land. We think that we have proven that. I think that the findings of fact will show that they are increasing the amount of water by 0.384 inches on Ms. Diaz's property, and they don't have the right to do so. And so when we go in and look at the issue of sanctions, it's clear that, for one, that the appellant was required to identify the offending pleading. And the statute, 120.569, requires a signature on a particular document. Now, none of that has been identified in this case. So we get into the pre-hearing stipulation. And so what happens with the pre-hearing stipulation is we're supposed to identify the facts in the law. We go all the way through the process, and they remain completely silent. And then the pre-hearing order suggests that, hey, if you fail to include an issue like attorney's fees, I'm not going to consider this. So again, it's just kind of a sucker punch at the end of the case to pull us into this court proceeding. So again, the Mercedes case goes on and talks about these issues. And I think it's important that the appellant's counsel put his name and signed the agreement in accordance with that pretrial order to suggest that, hey, I agree that these are all the issues. So to come back after the hearing and claim that circumstances have changed after the petition is basically the same as it was, we had, of course, had to go directly to the Water Management District rules and regulations. We had to go and identify what was at issue there. We hired an expert, and they like to try and say, oh, that I prepared the report, which is fundamentally not true. The report never came into evidence. So a lot of these things are just not appropriate. So let me say one last thing. It's taken a lot of courage to take on this case. And, the party, the developer is very powerful. Carlton Fields is very powerful. I'm not from Tallahassee. So the whole circumstance has really been challenging. It's created a lot of angst and injury. And so I look at myself and I'm like, no, you got to do this, because you can't just stand by and let somebody take somebody else's land. It's clearly wrong. And so, but this is not relevant necessarily to the facts. The fact is that the government has given this developer approval to completely remove and fill 93,000 cubic feet of stormwater in the retention basin and change it to detention with filtration effectively. All of the water ends up on my client's property.
Mr. Braswell,
I understand.
You're done with your time, so briefly sum it up.
This case is about Ms. Diaz's right to stand up against the government and against the developer and against Carlton Fields and say, you can't have my land. You can't use it for your stormwater storage. You can't alter my plat.
Thank you, Mr. Braswell.
Thank you, Your Honor. Just a couple quick points here. First, Mr. Braswell referred to the nexus with Rule 11. You asked about that as well. I think it is worth pointing out that Rule 11 was amended in 1993 to expressly give courts the discretion whether or not to impose a sanction in the first instance. It used to have the same shall impose standard that 12569 sub 2E has. Our statute has never been changed. It remains the same. Likewise, I think it's important to also note that the Donaldson case cited by the appellee in his brief and by the Mercedes court notes that Rule 11 itself is notice of a potential sanction. Every practitioner should know that attorney's fees are out there if you file a pleading for an improper purpose. The same is true in administrative practice here in Florida. Every attorney should know that 12569 sub 2E is out there. Judge Roberts, as to some of your questions regarding the motion to dismiss, I think it's also important to note that these resources relied upon by Mercedes talk about the ability to potentially resolve a claim earlier on summary disposition. That's not really an option when there's a recommended order authority that the judge has. 28-106-204 of the Florida Administrative Code authorizes motions for summary final order in cases where there's final order authority, no such authorization for summary disposition of recommended orders. Occasionally, they are filed, but on almost all events, they're deferred to the end of the hearing in any event because the litigant has a right to present all of their evidence under the Administrative Procedures Act. And a motion to dismiss simply does not provide that same thing. It's limited to the four corners of the pleading. You can't go outside of it to show anything that happened before the pleading or any of the evidence that's adduced at trial or through discovery. It's simply not an option, particularly when there are highly technical allegations made within the complaint. Again, we never alleged that this amended pleading was so obviously and recognizably frivolous on its face that it warranted sanctions. Neither did the administrative law judge. It was all of the circumstantial evidence which the court and the administrative law judge are allowed to consider under this court's precedent in determining an improper purpose. So again, simply put, a motion to dismiss would not have sufficed here. There was no procedure for summary disposition, and there is no requirement in any of these statutes or cases that have been cited that says you have to do this early in time to the offending paper. There are times where it comes out later. You have that right. And additionally, it goes to what the sanction should be in any event. What did you do? Were your expenses reasonable?
Let me ask you a question, I guess just jumping off on a hypothetical Judge Bilbrey mentioned earlier.
Yes,
what
Your
if
Honor.
the motion was filed 6 months after the proceeding ended? You know, certainly there's no express timeliness requirement in the rule, but what type of sanction would be appropriate even in that case?
Your Honor, it's hard for me to speculate about what kind of sanction would be appropriate in that scenario. I've not seen a case that specifically addresses that, and certainly nothing in any of these materials discusses anything like that. They simply say that there are times that you'd still need to go through the evidentiary portions of trial, and so that is what happened here, and that's why it was needed and why we would ask this court to reverse and remand with instructions to impose an appropriate sanction. Thank you.
All right, thank you both for your argument. Did we let Mr. Rogner have his own clicker over there? Nothing like hazing your opponent.
Too tall for me.
So, Mr. Weiner and Mr. Rogner, we're glad you're here so you can explain to us what we meant in Valcourt Williams. And if you're ready, Mr. Weiner, you may proceed.
Good morning, Your Honors, and may it please the Court. My name is Mike Weiner here from Tampa, Florida. And on behalf of the appellant, Ms. Soya, I'd like to reserve 5 minutes for rebuttal, please. Your Honor, this is a very important case, as you've alluded to, and it fundamentally is about two very, very important concepts. Number one being that of separation of powers and allowing the legislature to write the law of workers' compensation, and the responsibility of this Court to determine what that law means, as has been plainly written by the legislature. And number two, it's about precedent, the doctrine of stare decisis, and the responsibility of the judiciary branch to adhere to cases and follow its own precedent, to decide cases based on similar facts similarly, because to do otherwise comports, according to the Florida Supreme Court, neither with logic or reason. Also about precedent, it's about the concept of dicta and the concept of ratio decidendi. In other words, that cases are decided based on the precise facts and questions of law that are presented within those cases, and then a holding is issued. And all the other sort of ruminations or thoughts that a court puts down besides those precise points of law and that don't pertain to those precise points of fact are considered dicta. And that is precisely why the court's decision in Valcourt does not control the outcome of the instant case.
Well, let me understand you. In your initial brief, you say Valcourt-Williams was a personal risk case. The Hamlin, Century Insurance Hamlin analysis is unaltered. The risk here was a risk of a workplace slip and fall, which is a neutral risk, and everything else in Valcourt is dicta. I'm understanding you right. But then in the reply brief, I think you said that risk plays no part in the analysis. So which is it, and what does risk mean here?
Well, technically, I mean, if we're going to adhere to the supremacy of the text principle, right, and we're going to interpret the words of the legislature as they are plainly written, we don't find the concept of risk as being one that's present in the arising out of definition or really any other concept of 440. We agree there has to be occupational causation.
So Hamlin decided, 15 years plus after the statutory change is wrong, is what you're saying.
Well, I'm not here to say Hamlin's wrong, and I'm not here to say Valcourt is wrong. Those cases are cases that are decided based on risks or personal conditions, if you will, that are imported by the claimant into the workplace. And those cases have historically always received less favorable or more scrutinized analysis based on the arising out of doctrine, whereas cases like this, which is akin to Ross, Lanham, Caputo, Walker, Bryant, and a whole litany of other cases. There's actually probably a body of precedent that comprises at least 6 or 7 similar cases, which have always held that where the claimant brings no personal risk or no personal condition into the workplace, you don't have to consider that aspect of risk. The fact that the claimant is in the course and scope of her employment when she's injured is enough. And that is, at its fundamental point, what the definition of arising out of is, right? Not this definition that's been provided in the Valcourt case. And we would respectfully submit.
So in Valcourt, the argument, she was at her workplace. She was working and went to get coffee, much like someone that left their office to go to the break room to get coffee, and she tripped, and so she was entitled to money from her employer. Okay.
A fair question and a couple of, I think, interesting and valid points in response. Number one, and I think as Your Honor, Bilbrey alluded to in the dissenting opinion, Valcourt really, that's more about a course and scope question than it is an arising out of question. Because the legislature has told us what arising out of means, right? And it's a very simple definition. If the work is performed in the course and scope of employment is the major contributing cause of your injury, then you meet the arising out of test. Okay? And what we have here is we have a 1-0 victory, which is enough, because what we have is the claimant's work not only being the major contributing cause, but in fact it's the only cause of the injury that she had, because there are no other causes. The judge did not find, nor did the carrier actually prove or allege an idiopathic condition or a pre-existing condition. In other words, you fell because you've got this diabetic neuropathy in your leg, or because you have this back condition that makes your legs prone to give out. None of that existed in this case.
Just, for some reason, you're not paying attention, or you're clumsy. Is that a personal cause, or does it matter if it's a personal cause? So that
it doesn't matter.
Okay.
It's a great point, because historically we know.
So how do we rule out the notion? And I can't imagine the legislature ever thinking that if a person is at their home and they trip over their own dog, that somehow their employer owes them money. I can't imagine the legislature ever coming to that conclusion. So how do we take care of that situation? So if you trip over your own dog in your own kitchen getting your own coffee, that's not compensable. But other things like this case is. How do we get to that?
And I'm glad you asked that question, because it illustrates the concept that I'm talking about, precedent, about like cases being decided alike. So Valcourt's a unique case based on unique facts, just like Hamlin, right? Valcourt is a case about somebody working from home, taking a coffee break, getting and tripping over their dog, right? There's nothing about Valcourt's job as a claims adjuster that contributed to the injury that she suffered. Similarly in Hamlin, there was nothing about Mr. Hamlin's job as a sales associate that contributed to his getting injured when he stops his car from being repossessed.
Right,
So
and
what,
I understand that. I'm sorry. So in Valcourt, we did expressly abrogate some personal comfort cases. And so in those cases, what was the personal risk that was brought to bear such that our analysis should be any different from the case that we have before us?
okay, so, you know, the personal comfort cases, again, were expressly abrogated in Valcourt. Those were not necessarily arising out of cases. The decision there was that they didn't maybe necessarily use an arising out of definition. But more importantly, what Valcourt did not do is it did not expressly or impliedly overrule Bryant, Lanham, Caputo,
Right. Well,
Ross,
and
or
that's
any of the other,
that's a point well
Vigliotti, or any
taken.
other precedents of this court.
Right. Those unexplained fall cases weren't mentioned at all in the majority opinion, but I'm trying to understand the distinction between the personal comfort cases that were overruled, where there wasn't any arising out of discussion. It was just assumed. You're injured during the course and scope, a comfort break. There's no compensability, or there is compensability in those cases. So what is the distinction in the analysis that should be made?
Well, I would submit that it's really not a question for this case because this isn't, number one, a personal comfort case, right? So we don't have to decide issues of personal comfort. So it goes back to sort of my point that Valcourt is not the plenary answer to all things arising out of, because it only dealt with those narrow set of facts of personal risk imported by the workplace. That is not this case. They're two separate cases. So the personal risk cases and the Valcourt case of an imported risk of having your dog at work belong in a box over here. The risk of Ms. Soya getting injured at work when she has no pre-existing conditions, no idiopathic conditions that have been proven, and she meets the legislative definition of the work that she performed was the major contributing cause. In fact, it was the only cause of her accident because there are no other causes that were found by the judge. That's a totally separate case. And that's why Valcourt is fine to be a standalone case as it pertains to personal risk, imported risk cases, pre-existing cases, idiopathic cases. But the law always remains intact as it has been in Caputo, Lanham, Ross, Bryant. I mean, I beat these cases to death ad nauseum, I feel like, in the briefs because they're important, because it is the responsibility of this court to continue to follow that precedent in these cases where there are no such imported or personal risks.
Is it possible then to put those cases that you just cited under in this case, under the neutral risk category, under Hamlin, and the four cases that we overruled, or the majority overruled in Valcourt, would be personal risk cases?
I'm not sure I understand your question. I'm asking you to rephrase it if you could, please.
The unexplained falls, or just the workplace, my foot got snagged on the linoleum falls, those would be a neutral risk case. Certainly if, you know, a massage table collapsed on your client, that would have been a risk inherent with the workplace, which clearly would have been compensable. Had she been, you know, shot by a coworker that she was engaged in a romantic relationship with, had a plane crashed into the building, something, you know, totally outside of the norm, had she had a heart attack or a stroke, that could be categorized as a personal risk. Then I'm trying to conceptualize this under the Hamlin framework.
Okay. Given
that Hamlin was cited with approval twice in Valcourt, is that a reasonable way to think about it?
Yeah, I suppose it is. You know, in the sense that in this case, there is no personal risk, right? And we know there's no imported risk. So what do we have here? We either have a work-related risk, which I would submit to you there is, right? Because even in the dissent, we talk about, you know, falls in the workplace being the number 2 cause of accidents in the workplace, right? So falls are completely a foreseeable consequence. We know that the risk of falls is something that is inherent to work itself. It happens, it's ubiquitous, it happens all the time. So I would humbly submit to you that in the absence of a pre-existing condition, that a trip and fall in the workplace actually is a known work-related risk. And we don't have to prove fault. We don't have to prove that the employer created some dangerous condition on the carpet or that the lighting was inadequate, because if we do that, we erode the workers' compensation system into one that is based on fault and negligence, and that's the very antithesis of what the system is supposed to be.
You are into your rebuttal, but may I ask one
I'll
quick
give more time,
question? Assuming we agree with your argument that the JCC applied the incorrect legal standard, I believe it was in your initial brief, you said we need to reverse and remand for the JCC to apply the unexplained fall cases. But what analysis is remaining where the record here shows no personal risk was imported, there was no pre-existing condition? What's left to do on remand?
Honestly, I suppose probably not much. I suppose the remand would be with instructions for the JCC to enter a finding of compensability in favor of the claimant, because in the absence, right, the carrier's got 0 and we have 1 point, because we know that the work performed is the only thing that caused her to fall. That's a win, right? That is the definition of major contributing cause. It doesn't have, we don't have to win 7-0. 1-0 is enough. So the remand instruction would be quite simply to enter a finding of favor and compensability in favor of the claimant based on Caputo, Lanham, Ross, and the related line of cases.
Any other questions? Madam Clerk, would you give Mr. Weiner an additional minute for rebuttal, and of course give Mr. Rogner that minute also? You're not required to use any of those minutes.
May it please the court. My name is Bill Rogner, and I represent Health First and CCMSI in this appeal. Your Honors, Mr. Weiner and I are engaged in several of these, and he keeps saying it's about fault. This case has nothing to do with fault. It has everything to do with occupational causation. There were 3 factual findings that control this case. 1, the claimant fell for no known reason. 2, there was no condition at the workplace that caused or contributed to the fall. And number 3, at the time of the fall, she was not actively engaged in the duties of her employment, but she had completed her workday and was on her way to a luncheon with friends, which is a purely personal mission. Under those 3 facts, the only thing that ties this injury to the employment is mere presence at the workplace, which you have told us.
Mr. Rogner, we have a long body of cases that say that if you are injured at work for whatever reason, that it's compensable. And some of those cases may have been overruled in Valcourt Williams, but not all of them. And so how do we handle those cases? You know, for a long time, if you were at your workplace and unless you were doing something that you really weren't supposed to do, and you hurt yourself, that was compensable. And so the argument now is that we totally turned that around in Valcourt, or did we not totally turn that around in Valcourt?
Right. I understand.
So explain to me whether we changed the world in Valcourt, whether we changed the world on purpose in Valcourt, whether we changed the world by accident in Valcourt, or whether we just said that, you know, if you trip on your own dog in your own kitchen, that's not compensable.
Totally understand. If it was just about a dog in a kitchen, a 3-judge panel could have written that opinion that said if you trip over your own dog in your kitchen, it's not covered, right? This was not a 3-judge panel. This was en banc, and it was 11-2. And Judge Bilbrey, you wrote a passioned, well-written dissent.
Maybe it was overblown, though. I mean, maybe I got it wrong, and it could be analyzed under the Hamlin framework, and the dog's a personal risk. I disagreed with that, but the dog's a personal risk. And Hamlin was cited twice in Valcourt, still good law.
Right.
And here, a workplace trip and fall not caused by a personal factor is a neutral risk. So, you know, why can't we bring it back together with that? And, you know, I say the sky is falling. Maybe it hadn't fallen.
Okay. So first, I don't think any case that was decided interpreting arising out of before 1994 really matters, because the legislature didn't create the statute until 1994. And Mr. Weiner cited it. We all know it. It says arising out of is about occupational causation. That's why we're here today. Occupational causation. An injury arises out of the employment if work performed in the course and scope, separate concept, work performed in the course and scope is the major contributing cause of the injury. You talk about all the unexplained fall cases that you determined to be compensable. There are 4 after 1994. The first was Lanham. That's in 04. Then we get the troika, I call it, the 2012 trio that all came out within 3 months of each other.
And I say in dissent, what about those? The majority didn't address it at all.
Right.
They did explicitly overrule 4 cases that are real outliers. Holly Fruit, Crossing Road to buy cigarettes, Bayfront Medical, drive-in to a convenience store, Gravy, Eastern, basketball during a layover, Pan Am v. Wilmot, cigarettes during a layover. So, I mean, those are way far, could be categorized as personal risk. Right?
But if I can finish my thought, okay? So we have these 4 cases. The first was Lanham, and if you read Caputo, Caputo says this unexplained fall is covered because of Lanham. Then if you look at Walker, it says this unexplained fall is covered because of Caputo. And then if you look at Ross, Ross says this unexplained fall is covered because of Walker, Caputo, and Lanham. So it goes back to Lanham. What is Lanham? Lanham is identical to the 3 cases that were expressly overruled in Valcourt. Lanham is a personal comfort case where the claimant had left the premises, was walking on a sidewalk, and tripped and fell. Didn't fall for no reason. Tripped and fell. The court said in Lanham, that's enough because the claimant's entitled to coverage during personal comfort breaks, and then Caputo, Walker, and Ross just take that at face value. None of them applied the statutory language that requires occupational risk that's the cause of the injury, and that's what you said in the en banc opinion. You said, quote, the claimant must prove that the job contributed to the risk of injury, whether the injury follows fainting, a heart attack, or like here, a fall. Okay? You said it's about the cause. More simply, the arising out of limitation requires the risk that caused the claimant's injury be work-related. And you did cite, Judge Bilber, you cited 3 cases that were expressly overruled. But what the court said in preference, or previous to the express overrule of those cases, is you said, we have not always been accurate in our application of the arising out of standard. For example, and you give those 3 cases. That does not mean those are the only cases where the court whiffed on applying the arising out of limitation. I submit to you.
So, Mr. Rugner, moving about your workplace during the day, how is that not arising out of the work? I mean, we can't tell people that you have to sit at your desk, and if for an office situation, it's different if you're operating a backhoe, and those cases are clear.
Sure.
But for an office situation, if you get up from your chair for any reason and you hurt yourself, that's not related to your work.
That's not what I'm saying. There have been 27 cases that have gone to trial on Valcourt-Williams denials. 27. There are 8 appealed. 2 have already been determined in favor of the carrier. They were PCAs. Judge Ray, you were on both panels. There are 6 pending. Of those 27 cases that have been tried, more than half of them, the JCC determined that the claim was compensable, and they weren't appealed, and they were legitimately determined to be compensable. Examples: somebody like Ms. Soya, who she's a waitress in one of these cases. She's called by a customer. She turns rapidly, and it causes her to lose her footing and fall. That is occupational causation. Okay. This case, Ms. Soya, if it were true that the carpet were defective.
But doesn't that inject fault into it, that the statute says this is regardless of fault?
It's not fault, it's causation. What about the job, other than being there, has anything to do with Ms. Soya's fall? She's not working, she's carrying chocolates that she's taking to a friend, she's got her handbag, she's carrying her personal cup of tea, she's not interacting with a customer. She's not distracted by a coworker.
Well, what about the job didn't cause it? I mean, what was the personal risk that was introduced, like in Valcourt? What was the pre-existing condition that was there, like in a number of the cases that Valcourt relied upon? In other words, I don't see this as a competing cause case like those that were referred to in Valcourt.
Well, Mr. Weiner analyzes this case as a idiopathic injury case, that you must have an idiopathic injury for it to not be compensable. But if you read Valcourt is far beyond that, and it seems to be far beyond that intentionally. And it seems to me that the court had a very intense debate about what it was doing in Valcourt. And when Valcourt tells me that the claimant must prove the job contributed to the risk of injury when the injury is a fall, what did this job do to contribute to her risk of injury? Nothing.
What put her there was carpeting, there's lighting, she's walking. I mean, as Judge Roberts pointed out, somebody, sitting at their desk plugged in, maybe there's no risk of injury at that point, and they jerk their neck and they strain their neck. It's, potentially idiopathic. But somebody moving around at the workplace, doesn't the presence of the workplace and the person in the workplace cause a risk of injury?
No. Being present is never enough. You've said that in multiple cases. You said it, in fact, in Hamlin, which was my case. You said mere presence at the workplace is never enough. You must show an occupational risk. As the statute says, you must show that work performed is the major contributing cause of the injury. And Judge Bilbrey, I know you're now saying that perhaps your dissent was overblown, but your dissent, talking about the neutral risk, said, prior to today, a workplace injury from a neutral risk, not caused by an idiopathic condition, was compensable. But in this case... Because I perceive the dog as a neutral risk, like a purse or something like that, but perhaps the majority perceive the dog as a personal risk under the Hamlin framework. Well, had she tripped over a stair at work, or had she tripped over her table where she does her massages, these are work-related risks that cause the injury.
But I mean, there's tables and chairs in somebody's non-workplace life, so where is the line drawn?
The portions of Mr. Weiner's brief that I think are a bit histrionic is he says, for example, chainsaw example. He uses a chainsaw in most of these briefs. And he says, well, someone who cuts trees for a living will no longer have a compensable claim if they lop their arm off with a chainsaw at work, because maybe they have a chainsaw at home that they use on the weekends, which I think is nonsense. I would stipulate that's compensable every single time. The Byrd case in 1989, as Florida Supreme Court case, says, arising out of requires that the injury is caused by a risk inherent to the nature of to the work in question, okay? Let's talk about the defect in the floor, Judge Bilbrey. Had there been a defect in that floor that caused Ms. Soya to fall, it would have been covered. Why? Because the defect in that floor exists in that floor at work and nowhere else on the planet. The fact that there may be a rip in that carpet that caused her to trip, caused, not her fault, not the employer's fault, caused occupational causation. The fact that a rip in the carpet at work would be the cause of her fall, that rip exists only at work and nowhere else. It doesn't exist in her non-employment life. It's a very simple concept. The way I look at these cases, and I've been doing this a really long time, and when Caputo, Walker, and Ross all got decided in a 3-month period in 2012, I went, they just got that wrong. They just got it wrong, because it conflated two separate concepts. It basically said the injury arises out of the employment because the claimant's in the course and scope of the employment. That's what those cases said. It arises out of the employment because the claimant's at work. And that was wrong. That's not what the statute says. Course and scope, all that is time and place. Where am I and why am I there? If I'm at that employment or that building where Ms. Soya fell down, I'm Ms. Soya and I'm there because I'm at work, I'm in the course and scope. But that has nothing to do with occupational causation. I challenge him, identify the cause. What was the cause of the fall? Well, I say the claimant, just like a plaintiff, bears the burden to prove their case. And in this case, the only reason the claimant can't prevail is because the claimant did not prove an occupational cause of her fall other than I'm at work. And that's course and scope. That's not arising out of.
How do you distinguish major contributing cause from fault? What's the difference between the two of them?
Well, major contributing cause, as the statute says, requires medical evidence, and major contributing cause is a medical concept. And so, for example, if she tripped on carpet and fell, the injury arises out of the employment, but the question of whether her broken arm is related, it's a medical question. Is the major contributing cause of her broken arm the fall on the floor? That's causation. I'm talking about occupational causation, which is the relationship between the injury or the accident and the fall, which is exactly what the statute says. The statute for this concept says the accidental injury arises out of the employment of work performed in the course and scope of employment is the major contributing cause of the injury. So what we've got to do is they've got to establish that this accident was caused by a risk created by the employment. If I'm a roofer and I'm working at height and I trip over my own feet and I fall off the roof, the cause of the injury is the inherent risk of working at height. That's covered every single time. If I cut my arm off with a chainsaw at work, regardless of whether I have chainsaws at home and work with them on the weekend, that's an inherent risk to the occupation. It's covered every single time. I say that the only thing that Valcourt Williams has done is it has determined that the I fell down for no reason and my employment did not contribute to the risk of me falling down is not covered.
Well, you make the point that by my mentioning Ross, Caputo, and those others, we've implicitly overruled them. I mean, I think you're ascribing a lot of power to a dissent that, I mean, a dissent can't overrule anything. You would agree with that.
I totally agree, but when the majority, the 11 judges in the majority, say the claimant cannot prevail unless the job created the risk of injury, or the risk of the injury, if that's what the majority says, I should win this case, because they've not identified a risk of her employment that caused her to fall down. Nothing. Beside her being there.
Right, and of course, Valcourt was a personal risk case, so I mean, it's a different case than our unexplained fall case. But I want to ask you real quickly about your alternative argument, which is even if we are bound by the unexplained fall cases,
Yes.
Caputo, Walker, Ross, the employer carrier still prevails because in those cases the claimants were, actively engaged in work, and that was not the case here. But didn't we say in Vigliotti and even in Valcourt that that's an improper analysis? You don't have to be actively engaged in work in order to be covered under work perform. Well,
I agree that you may have said that in Caputo, Walker, and Ross, but I think they're distinguishable for several reasons. Caputo, Walker, and Ross, the judge made a factual finding that all were actively engaged in the duties of their employment. That's what the JCC made that factual finding. Number two, they all had a reason for the fall, and I think it was a work-related reason. In Caputo, they said the claimant fell while cutting shelving. Okay. Walker, the claimant slipped and fell. If Miss Soya would have slipped on a banana peel that was left on the floor, she's got a covered claim because the work-related risk, the risk at the employer, caused the injury. Ross, foot caught on linoleum and it caused her to fall. That was what Miss Soya tried to prove in this case. She said, my foot got caught on sticky carpet and it caused me to fall. If the judge said, I find as a factual matter that carpet was sticky and that carpet caused her to fall, she wins her case. It's a factual issue. And in this case, the judge found that no condition of the workplace caused or contributed to the fall. That's the key to the case. Thank you.
Thank you.
Your Honors, may it please the court. A lot to unpack here. So first of all, let me get to the core issue of why this court should reverse. And, under Valcourt, the test was that a claim is only compensable if a claimant would not be exposed to a risk in her non-employment life. That is not the test of arising out of under Chapter 440. That's just simply not the legislative definition. And the judge did not apply the definition of arising out of not only legislatively, so he did not honor the supremacy of the text clause and did not plainly apply the statute. He also erred because the judge did not follow binding precedent in factually identical cases in Caputo, Langham, Ross, etc. Those all cases are the same. Yes, a claimant falls, but there is no personal risk. There is no imported risk in those cases. And that's why those cases control the outcome of this case. And that's why Valcourt belongs in its box and is a case that is appropriate applied only in the context of where there is an imported risk or a personal or idiopathic condition that is proven by the employer carrier. That has always been the case law of this court, tracing its origins back to Acker, Dokapul, and the rest of the cases this court relied upon in Valcourt, which coincidentally, as Your Honor mentioned, all were personal risk cases. As I mentioned, the legislature has given us a definition of what occupational causation is. It does not mean risk. We don't have to prove that there was some perilous, dangerous condition, that we don't have to prove fault. That's antithetical to the very purpose of the Workers' Compensation Act. Yet that's what the carrier, in a sort of indirect way, is trying to say that the claimant needed to prove, that the judge should be upheld because the claimant couldn't prove that the carpet was worn or frayed. Well, those are negligence considerations. They have no place in the world of workers' compensation. Judge Ray, you brought up a very, very important point that I need to amplify about the actual performance of one's job duties, okay? And, the carrier would have you believe that because Ms. Soya wasn't actively massaging a client at the time she was injured, well, then she must not have been, her accident could not have risen out of her employment. But I would submit to you that there's nothing more fundamental or nothing more incidental to your employment than actually coming to work, getting set up, and leaving work every day. Without that, there is no work that can be performed in the course and scope of employment. And so tracing its origins back to Vigliotti, where this court squarely rejected the position of the employer carrier, that no, you're only actively engaged in your work while you're doing your job as opposed to actually walking and coming, going and coming in the confines of your employment. I mean, to take the analysis of the carrier's example to its logical extremes, if one of your honors trips and falls down the stairs leaving here, that's not compensable because you're not actively deciding a case while you're here, so you're not technically,
Well, they would distinguish Vigliotti because there was some substance on the ground there. So, I mean, like the banana peel or something like that, why does that not matter?
Because it doesn't matter, because it's an issue that pertains to fault. And in Vigliotti, this court expressly said this is why we don't want these considerations, because if we start allowing these considerations to come in, then we become a fault-based system. And that's what turns the workers' compensation system on its head. And it's the complete antithesis of what we're here to do. Is there occupational causation does not mean is there risk, is there a banana peel, is there water on the floor. Occupational causation simply means, as defined by the legislature, is the work that you're performing, which in this case is walking in and out of your massage room. That's part of the work that she performs. Is that the major contributing cause of your injury? Yes, it is the only cause. There are no other causes. There are no other reasons why Ms. Soya fell other than the work that she was doing. And that work included not just massaging clients, but also walking in and out of the massage room so she could do the things that are necessary, incidental to the preparation of and the end of her day. And that's why this court should reverse. Thank you, Your Honors. We appreciate your time.
Thank you both very much for your argument. It was certainly interesting and gave us a lot to think about, and we appreciate it. We are adjourned.
All rise.
Maybe this is a backdrop. My dad and I usually come here all the time.
Yeah, well,
And so now he couldn't make it, and And so I get the next best thing.
Oh, that's so awesome. I was wondering, while I was sitting there, if, that was father-sons,
Yeah.
I mean, that's good for you.
I think so. Yeah.
All right, glad to do it.
So next time it'll be a father-son troika. It'll be the three of us.
Hey, there you go. Come on. I wish I had a few more minutes. I got another hearing. I scared for a few minutes, so I got to keep moving. All right, maybe the next